a lot of people joined already, so I'll make a start. And as Leanne's explained, it's going to be recorded anyway, so anyone joining a bit later can catch up on that. So as an introduction, my name is Kerry Wagner. I'm a solicitor at Irwin Mitchell and I'm based in the Sheffield office in our Court of Protection team. So Helen and Leanne have very kindly invited me to run a webinar for you all, aiming to provide a bit of a general overview of the Mental Capacity Act, lasting powers of attorney and deputyships, all things that you may have sort of heard bandied around before and just want a bit more information on. So hopefully it's going to assist and be relevant to your circumstances as well. So in terms of my area of expertise, I specialise in court of protection work, focusing on the property and financial side for individuals who in the main have been assessed as lacking capacity to manage their own property and financial affairs. So my team often deal with applications to appoint a professional deputy or a lay deputy for a person lacking capacity, and we also deal with management of funds through trusts as well. So just moving on to the next slide, a bit of a general agenda for this evening. So over the course of the next hour, you'll see from the slide I plan to cover a bit about Irwin Mitchell, then I'll go into the main part of the presentation covering what I've just mentioned about the Mental Capacity Act and sort of the different avenues available depending on a person's capacity to make certain decisions. So just a bit about Irwin Mitchell. So we're a national law firm. Some of you may have heard of us. We were founded in 1912 and are now one of the largest full service law firms in the UK, with numerous offices around the country as well. So here at Irwin Mitchell, we have a specialist court of protection department, largely dealing with financial deputyships, but we also deal with attorneyships and damages management through trusts. So we're currently in the process of appointment for approximately 1,250 financial deputyship cases. I've also mentioned on the slide a bit of information about some other departments that may be relevant and that we'll sort of touch on this evening as well. So we've got our Public Law and Human Rights Department. So they consist of specialist lawyers dealing with issues such as health and welfare matters, public funding, care placement issues, education issues, and they also deal with health and welfare deputyships. We also have our Tax Trust and Estates Planning Department dealing with issues such as wills, lasting powers of attorney, estate administration, tax planning and compliance issues as well. So that's a bit of a brief overview of Irwin Mitchell and some of the work we do. So I'm now going to move on to an overview of capacity, covering what capacity is, why it matters, along with why this might be relevant to yourselves as well. So capacity in its most simple form is essentially someone's ability to understand and their ability to make decisions about their life. So people can lack capacity for all kinds of reasons, and capacity is something that can fluctuate. So individuals can be assessed as having capacity to make certain decisions at a certain time, but they may lack capacity in the future or on a different day. So to make sure that an individual is properly safeguarded and their rights are being upheld, a capacity assessment should always be considered when a decision needs to be made and there is a question over that individual's capacity. So as you'll see from this slide, the Mental Capacity Act 2005 covers England and Wales and came into effect in 2007. So this is the legal framework for decision making for people who are over the age of 16 and who may have been assessed as unable to make their own decisions due to a lack of capacity. So such individuals who fall under the Act may need a bit of support in making certain decisions, or they may need someone to make those decisions on their behalf. So the Mental Capacity Act is wide-ranging in scope. It deals with personal welfare issues and also property and general affairs of an individual. So it essentially covers any decision which that person cannot make for themselves. So I'm briefly going to go into a bit more detail on the Mental Capacity Act and touch upon on this slide the principles that underpin the spirit of the Act and the work we do, and also what principles someone should apply when making a decision on behalf of someone that lacks capacity. So these are all set out on the slide. So firstly, there is a presumption of capacity. So that means that a person is presumed to have mental capacity for a decision unless proved otherwise. Secondly, all practical steps should be taken to help a person come to their own decision without success before they are treated as unable to being able to make that decision. Thirdly, someone can't be assessed as lacking capacity just because that person makes a decision that's considered to be unwise. So just because, for example, someone might not have made the same decision as that person, or they might find the decision quite unusual, this does not automatically mean that that person lacks capacity. So fourthly, if someone is found to lack capacity, then any decisions or act done on behalf of that person should always be made in their best interests. And I'll go into a bit more detail on that further on in the presentation. And finally, before taking an act or making a decision for someone assessed as lacking capacity, consideration should always be given as to whether the desired outcome could be reached in a less restrictive way. So the least restrictive approach on the individual should always be taken. So as you can see from those, hopefully from those above principles, the spirit of the Mental Capacity Act is to protect and safeguard vulnerable individuals and also to enable individuals to participate in decisions as much as possible. So even where someone may have been assessed as lacking capacity to make a decision, the Mental Capacity Act is designed to empower those individuals as far as possible and make sure that any decisions being made are being made in what's deemed to be in their best interests. So moving on to the next slide is, so what is meant by a lack of capacity? So where there's a need to assess the mental capacity of an individual for a certain decision, this should always be done by an appropriate assessor. So for example, a medical professional, social care professional. The Mental Capacity Act quite helpfully defines how capacity to make decisions is to be assessed and the consequences if an individual is assessed as lacking capacity. So there is a very clear framework for professionals to work within when assessing someone's capacity. So I'm going to talk about the test in a bit of detail. So it's a two-part test within the Mental Capacity Act. And section 2, first of all, of the Act states that a person is unable to make a decision for themselves, so i.e. they lack capacity, if at the material time of that decision they are unable to make a decision in relation to that matter because of an impairment of or a disturbance in the functioning of the mind or brain. Now, going on to the second part of the test on the next slide, this then looks in a bit more detail about a person being unable to make a decision for themselves. That incorporates that a person is unable to make a decision for themselves if they are unable to understand the information relevant to the decision, if they're unable to retain the information, if they're unable to use or weigh the information as part of the decision-making process, or if they're unable to communicate their decision, so whether by talking, sign language, or any other means of communication. So if we're going back to the general principles of the Mental Capacity Act, All practicable steps must be taken to help the individual come to the relevant decision themselves. So there's a lot of literature that I'm sure some of you have already accessed online, but there's a lot of literature and guidance on how the Mental Capacity Act works and how it applies, including the Code of Practice, which helpfully sets out some steps that should be taken to help someone make a decision for themselves. So, for example, when assessing someone, you should look at using language appropriate for the person, explaining the pros and cons of making a decision in a certain way, and also looking at where a decision needs to be made. Consider whether does that individual need any communication aids to help them make the decision. What's the best time of the day for that decision to be made for that person? Are they more alert in the morning? Are they more alert in the afternoon? All these factors have to be considered in order to sort of give the best possible chance for that person to make that decision themselves. As I say, it is about empowering that individual and giving them as much autonomy as possible. So just a little bit more detail on capacity. For the assessment of an individual's capacity, every decision is what we say is decision specific. So this means that the assessment of an individual's capacity has to be based on their ability to make a specific decision at that specific time, not their ability to make decisions in a general approach. So this is outlined. I've just referenced a case on there about being decision specific. So, for example, an individual could be assessed as lacking capacity to manage their finances, but they may at the same time be assessed as having capacity to make a will, or separately having capacity to make decisions about their care or where they live. So it is very much decision by decision. And just because someone might be assessed as lacking capacity to manage their money, it should not automatically be assumed that, they lack capacity for other decisions as well. So I've also reiterated on this slide the points I've mentioned about unwise decisions is not necessarily a lack of capacity, and also confirming the need for capacity to be confirmed by a suitably qualified practitioner as well. So moving on, I'm now going to look at sort of decision making when an individual lacks capacity and what the Mental Capacity Act says about that. So the Mental Capacity Act at section 4 sets out a framework for considering what is in a person's best interest. So if there is a decision maker appointed to make decisions for that person, that decision maker should always consider the following that I've set out on the slide. So they should always consider any past and present wishes and feelings of the individual. This could be via a written statement previously made, any beliefs and values the person would likely have if they had capacity, any factors the individual would consider in the decision if they were able to do so. And also it sets out that other people should be consulted if appropriate. So if an individual lacks the capacity to make a decision, then where appropriate to do so, family members, friends should also be consulted on the decision to gain their views, and obviously they're on the ground and know the person best in most cases. So the Mental Capacity Act helpfully sets out kind of how to hopefully make a decision in that person's best interests. So now we've gone through the Mental Capacity Act and a brief overview of kind of assessing mental capacity, I'm now going to look at sort of the structures for supporting people who either lack capacity or may lack capacity in the future but have been assessed as having that now. So first of all, I'm going to look at lasting powers of attorney and talk to you about those. So if a capacity assessment is done and that finds the individual has capacity to, say, manage their finances or to make a lasting power of attorney. If the person is 18 or over, they can choose to make a lasting power of attorney. So this is a legal document which appoints an individual attorney or attorneys to act on that person's behalf for certain decisions. So as I say, within a lasting power of attorney, the person can choose to have more than one attorney. So attorneys can be appointed jointly, meaning that they would have to make all decisions for that person together, or they can be appointed jointly and severally, which essentially means that one of the attorneys could make a decision on their own, or they could make it with the other attorney as well if they wished. So the person who creates the lasting power of attorney is called the donor. And as I say, the donor must have capacity to make the lasting power of attorney. And that is really important to make sure that the legal document is valid. So it's only valid if the person has had capacity to make it. So there are two types of lasting power of attorney, and they are two separate documents. So the first one covers property and finances, so property and financial affairs lasting power of attorney, and that covers decisions about finances. So, for example, decisions about collecting benefits for the person, dealing with bank accounts, running someone's day-to-day finances, so dealing with shopping, bills, property, investments. And then separately is the health and welfare lasting power of attorney. And this covers decisions about residence care and any sort of medical treatment related decisions as well. So with lasting powers of attorney, with one sort of important distinction that I'll go on to, they take effect once they're registered with the Office of the Public Guardian. So the donor can make the lasting power of attorney, register it with the Office of the Public Guardian, and then it's there ready to be used. If any changes are needed to the lasting power of attorney in the future, or if the donor wants to revoke the power of attorney, that can only be done when the individual still has capacity to do so. So as I say, there is a bit of an important distinction between property and finances and health and welfare. So I will just explain that on the following slide. So as I say, this runs through a bit of repetition, but a person must be 18 to sign a lasting power of attorney and have capacity. So between the two types of lasting power of attorney, the property and finance lasting power of attorney can be used whilst the individual has capacity with their consent. So what that means is once the lasting power of attorney is registered with the Office of the Public Guardian, if the donor still has capacity, with the donor's consent, the attorney can sort of make financial decisions on their behalf if needed. So that can be useful in situations, for example, where the donor might be unable to get to the bank and wants their attorney to do that on their behalf. It can also be used, obviously, when the donor loses capacity in the future as well. So it's a way of future-proofing for a time when that person might lack capacity to manage their money in the future as well. Now, with the health and welfare lasting power of attorney, this can only be used by an attorney once it's registered with the Office of the Public Guardian, and also only once the individual has lost capacity for health and welfare decisions. So that's a really important distinction. So it cannot be used whilst the person has capacity to make health and welfare decisions. That's kind of the key difference between the two and when they're ready to be used. So in terms of lasting powers of attorney, if an individual is assessed as having capacity to make one of those, then I've just kind of gone on these slides to some practical aspects that you might want to consider. So there's some quite lengthy documents to complete for the lasting powers of attorney, and they deal with who the person wants to be their attorney, the extent of the attorney's authority, So, for example, the donor could add restrictions into the document, so they might want their attorney to be able to make most financial decisions, for example, but they might want to restrict the attorney's ability to sell property or other financial decisions on their behalf, which can be set out in the document. So the document as well also requires a certificate provider, and the certificate provider's role is essentially to confirm that the person making that document has capacity and an understanding of the document they are signing. So the certificate of capacity has to be completed by an independent third party at the time the lasting power of attorney is signed. So the certificate provider as well has to be over 18. They can't be related to the person making the lasting power of attorney or any of the people being authorised to act on that person's behalf within the document, so they can't be related to the attorneys. There are sort of two options on who can be certificate provider. So it can be someone who's known the individual for over 2 years, such as a friend or neighbour, or it can be someone with the relevant professional expertise, so can often be carried out by a doctor or a solicitor as well. So with the lasting powers of attorney, there is a very strict signing order in terms of who signs first, who signs last, and the Office of the Public Guardian will only accept the documents for registration if they have been signed in the correct order. So as I've set out as well, there is a registration fee of £82 per document to be registered with the Office of the Public Guardian. And lasting powers of attorney as well, it is worth bearing in mind that they do take a while to register with the Office of the Public Guardian. So if someone has been assessed as having capacity to make that document, and they then proceed to have one prepared or prepare one themselves, it's usually advised that you should apply to register it as soon as possible, just because of that quite significant delay between making the lasting power of attorney, applying for it to be registered, and actually getting the registered document back to use. So once you do get that document back and it's been registered, the attorney doesn't have to take over everything immediately. They can use their powers intermittently if appropriate to do so. So again, it's kind of going back to those mental capacity considerations of, if a lasting power of attorney is made and the person subsequently loses capacity, if the attorney is then acting on their behalf, it's looking at what decisions might they be able to make themselves, what decisions does the attorney need to step in and make on their behalf. Okay, so whilst it's important for individuals to also think about making lasting powers of attorney if they have capacity, I've also just flagged on this slide that it's a consideration for parents, guardians and sort of main caregivers to consider preparing lasting powers of attorney for themselves as well. So this is particularly important, obviously, if there's dependent individuals. If their main caregiver loses capacity and a lasting power of attorney is not in place, it can end up then being sort of a lot more of a complicated, long-winded process. Lasting powers of attorney are not always at the forefront of people's minds, and they are often prepared and typically associated with elderly people when a loss of capacity seems quite, a realistic prospect. So they are often done or thought about too late. If they are thought about too late and you lose capacity, obviously the lasting power of attorney is not an option at that stage. So we always sort of say they are as important as having a will. You hope you never need them, but it's possible that you might. So with making a will, you might find that it's often suggested, if you do go down sort of a legal route, that you make a lasting power of attorney as well. Okay, so moving on, I'm now going to briefly explain. So I've just spoke about lasting powers of attorney and that kind of being the option where an individual has capacity. So I'm now going to move on to briefly explain the court of protection, what the court of protection is, and how it fits in with the capacity considerations and the legal framework I've just gone through. So the court of protection will come into play if the capacity assessment finds the individual lacks capacity to make a certain decision. So the court of protection is a specialist court, and it's designed to protect vulnerable individuals who have been assessed as lacking capacity to make certain decisions for themselves. So it's divided into two areas, so a similar sort of split to the lasting powers of attorney. So the court of protection is divided into property and affairs, so a focus on finances, and also health and welfare, so covering things like medical treatment decisions, residence, care. So the court of protection can make a one-off decision on a specific issue. They might issue a declaration or an order on a specific issue, or the court can appoint a deputy where a series of ongoing decisions are required. In those cases, it would make more sense for a deputy to be appointed with authority to make those ongoing decisions on a regular basis. So the next slide just sort of goes on to that in a little bit more detail as to who can be appointed as someone's deputy. So if a person doesn't have capacity to make a lasting power of attorney, then either a lay individual, such as a family member, parent, guardian, can be appointed as an individual's deputy, or a professional deputy can be appointed. And both avenues involve applying to the Court of Protection to be allowed to make decisions on behalf of that person. So it is quite a lengthy application process if a deputy is needed, with numerous forms to complete. And with the application to be someone's deputy, there has to be supporting capacity evidence to confirm that that person does lack capacity for that particular decision. So, as I say, the Court of Protection can either make one-off decisions or appoint a deputy where ongoing decisions are needed. So in Court of Protection proceedings, the person involved, so the person the proceedings relate to, are referred to as P, the protected party. So on this slide, I've just gone on in a bit more detail about the types of deputyship and what sort of the appointment process is like. So they can be appointed to make decisions about property and financial affairs or health and welfare decisions. And similar to attorneys, deputies can be appointed, so there can be a single deputy, or there's the option to have a joint deputy or joint and several deputy as well. So the law states that deputyship should be as limited in scope and duration as possible. So the Court of Protection will specify which decisions the deputy has authority to make and which they don't, depending on P's individual circumstances. So it might be, for example, that if an individual has been assessed as lacking capacity to manage their finances, and a financial deputy is required, the Court of Protection might make an order appointing someone as their deputy to have authority over the financial affairs. But within that order, they might add restrictions and say the deputy can't purchase property on that person's behalf without getting further authority from the court. So the Court of Protection look at the circumstances of the matter and sort of reach an order as to what they deem appropriate and in P's best interests. So with health and welfare deputyships and health and welfare decisions, I would say that health and welfare deputyships are a lot rarer than property and financial affairs deputyships. So there are some specific issues that are always excluded from health and welfare deputyships. So there are certain things that a health and welfare deputy do not have authority over. So those include, I've mentioned them on the slide, so the authority to refuse consent to the carrying out of or continuation of life-sustaining treatment to P, and also the power to prohibit another person from having contact with P. So they are a lot more, you know, there are limitations on health and welfare deputyships, and the Court of Protection are more hesitant to make health and welfare deputyships as well. Okay, so just going on to, again, some more practical aspects of deputyships and things you might want to consider. So if a deputy is needed for an individual, there are court fees to make that application. So for deputyships, the current application fee is £408, and there's also a hearing fee of £494 if the Court of Protection decide that a hearing is needed. So following appointment, a deputy is governed by the principles of the Mental Capacity Act, and the deputy is also required to report to the Office of the Public Guardian, so the government body that supervises deputies. So it's a lot more of a responsible role. There's a lot more requirements of a deputy. So, for example, they have to prepare an annual report to the Office of the Public Guardian, detailing any significant decisions made on behalf of that person within that year, and also retaining sort of financial records and reporting that to the Office of the Public Guardian each year within that report. So there are also ongoing fees if you're appointed as someone's deputy. So there's the assessment fee, which is payable to the Office of the Public Guardian, and that's currently £100. And then there's annual fees as well that have to be paid to the Office of the Public Guardian for supervising deputies, and that's currently £320 a year. There may be exemptions available depending on an individual's financial circumstances, and the same applies to the Court of Protection fee as well. In some cases, an exemption is available. So, as I touched on before, there are more financial deputyships than health and welfare deputyships. And in accordance with the Mental Capacity Act, a decision by the court on welfare matters is often preferred to the appointment of a deputy. So, you know, if there's a one-off health and welfare decision, an application can be made to the Court of Protection for that decision. And the court usually prefers that it's a very collaborative approach, and decisions for health and welfare are sort of made in that person's best interests. But where some examples where a deputy for health and welfare might be required, I've detailed them on the slide. So, for example, where there'll be a series of linked welfare decisions that need to be made over time, and it wouldn't be beneficial or appropriate to require each and every one of those decisions to be made by the court. Or also where there's a history of sort of serious family disputes that could have a detrimental effect on the person's future care unless the deputy is appointed to make necessary decisions. So, as I say, health and welfare deputyships are a lot less common than property and financial affairs deputyships, but they are, you know, they do exist and they are there, and the Court of Protection will look at that in certain circumstances. Okay, so I then thought, just to sort of, before we get on to questions, I feel like I've spoke to you a lot about kind of the law and the differences between sort of lasting powers of attorney and deputyships. I thought it would be helpful to pull everything together into a bit more of a practical example to sort of make sense of it all. So the example I've got on the screen is AB. So AB is 18 years old, has a learning disability, and means that he cannot live independently. So as I've detailed, so he lives in a residential care placement, doesn't have any property or savings. His parents are appointees for his benefits. So there is an option where an individual is receiving state benefits, and that's the capacity that the DWP can appoint appointees to manage those benefits. So in this case, AB's parents are his appointees. It also notes his care is funded directly via the local authority / NHS. So AB can manage small amounts of money and is supported with that via his care team. He can also make decisions about his care and treatment, but he does not have capacity to decide where he lives. And the slide confirms that an assessment has taken place in relation to this by his treating psychologist. So all the professionals involved in AB's care and his parents agree that the residential care placement meets AB's needs. AB likes his placement and he wants to stay there. His parents have always been consulted about decisions relating to his finances, his care funding and his health and welfare, but they've heard from other parents that now he's turned 18, they might need greater authority to continue to be consulted in the same way that they have been before. So they're concerned about being excluded from decisions for AB. So on the following slide, I've just put some considerations to think about for this example. So first of all, obviously we've been told that AB lacks capacity in relation to care, but in relation to finances, consideration should be given as to whether AB might have capacity to make a lasting power of attorney now that he's turned 18. If he lacks capacity, and also looking at the Mental Capacity Act, the principles within the Mental Capacity Act should always be considered in this case because AB is over 16. So this requires those interested in AB's welfare to be consulted if he does lack capacity to make certain decisions, which we know he does. So if AB lacks capacity to manage his finances and make a lasting power of attorney in respect of that, the Court of Protection can appoint a financial deputy. However, in the situation we've described, this might not be necessary because I've spoke about that AB's income is solely consistent at the moment of his benefits, and through the DWP, his parents are able to be appointees for his benefits, which can continue, and there are no other finances to manage. If we were saying that AB had other assets that needed managing on his behalf beyond his benefits, it may be then that yes, a financial deputy would be appropriate in this case. So it's looking at the individual circumstances and what there is to manage. So in relation to where AB is living, if all parties agree that it's in AB's best interests, then a best interest decision can be made in relation to this and he can remain at the placement. So that's without involvement of an application at that stage to the Court of Protection to make that decision. So in the current situation, AB's parents don't require any additional authority to continue to be consulted about his finances and welfare. However, I've noted at the bottom that if a dispute did arise in relation to where AB was living, then an application could be made to the Court of Protection for a best interest decision to be made. In this case, a continuing health and welfare deputyship might not be required, and it may be that health and welfare decision could be dealt with by way of a one-off order in that situation. So that's just a bit of a practical example to pull everything together. So that's kind of all of the main slides. I've just popped up here sort of a few contact details, and obviously, as Leanne said at the start, they will be circulated via the recording. So I've popped my number and an email on there, and then Niall and Beth are the partners in my team, and also directors acting as professional deputy on behalf of individuals lacking capacity. So that brings me kind of to the end of the overview. So there is sort of 15 minutes or so for any questions, and I'm sure Leanne and Helen have been collating some within the chat.
Thank you so much for that, Kerry. That was really great, and it's helped me understand a little bit more about the process and ask a few questions about our situation. So really helpful for
Oh,
me.
good.
We have a couple of questions. I'll start in the Q&A panel, and one of the questions we've got here is, are the deputyship fees charged twice, i.e. is there one for the finance and one for the health and welfare, or is it just one per application if you're attempting to get deputyship for both types?
It is. They are separate per application. So the application for property and finance is different. They're different forms as well for each. So it's a little bit confusing because some are the same forms, but the sort of first form that you complete is called a COP1, and it kind of guides you then as to what you need for each one. So there is an application fee charged separately for those. As I say, it may be that you might be entitled to an exemption on the fee or a fee remission, and there is a bit of information on the gov.uk website about sort of the criteria for those as well.
Okay, fantastic. And I'm just going into the chat panel. So some of the people attending tonight in our membership are based in Scotland. So everything you've described is makes perfect sense for sort of England and Wales. Hazel's asking that adults, how does this relate to the Mental Capacity Act for adults in Scotland, or the Incapacity Act 2000? And also, is power of attorney the same in Scotland as England and Wales?
That's not something I am unfortunately an expert on. It is a different, have trained sort of within England and Wales, so I can possibly find that out and give you a bit of a sort of some pointers on that, because it is a different procedure, I understand, in Scotland.
And I mean, maybe the question perhaps is, do Irwin Mitchell support cases in the Scottish legal system? Is that something Irwin Mitchell do deal with?
Don't believe we do. We do have an office in Scotland, so again, I will double check and make sure that that is circulated if it is something that we can help with.
Okay, that's great, because I think also in terms of the sort of terminology, it's a little bit different, isn't it, in
It
Scotland,
is,
where it's
yeah.
deputyship versus is it guardianship in Scotland?
Could be.
Okay, I don't, obviously your expertise is based in England and Wales, but it would be interesting again if it was possible to find out some information, if that is something that Irwin Mitchell can help with.
You know. Yeah,
that would be great. So, I mean, one of the questions quite early on was around the difference between power of attorney and guardianship. But I do think that you've, certainly in terms of deputyship, you've definitely answered that question, to my mind, in the presentation, and done a great job of answering that. And then Hazel's also put, in Scotland, if you're going for guardianship, you can apply for legal aid on behalf of the young person. And is there something similar that's available in the UK, which you touched on there? Where would somebody go to find out whether they're eligible for legal aid?
So legal aid itself is sort of only applies in quite limited circumstances now. With applying to be appointed as deputy, as I say, it is a lengthy process. There are the court application fees, which there is literature on the gov.uk website, as I say, about whether you might be entitled to a fee remission or an exemption, and what circumstances apply in order for you to be eligible for those. With deputyship as well, it's not the case that you have to instruct a solicitor to help with those forms. The forms are available online on the gov.uk website. There is, guidance documents on those to help you kind of complete those and what needs to be done. So, whilst it can be a costly process, there are ways of trying to reduce those costs and keep the costs down. It's not always the case, as well, as I've explained, depending on what there is to manage, that a deputy is always required. It is very much dependent on the individual circumstances.
Okay, going on to sort of the next question, we've got many SMSs. We tend to often refer to our individuals with Smith-Magenis syndrome as SMSs. They simply don't have capacity. Is there a templated approach, or does everything have to be sort of done from scratch each time you apply for one of these things?
So it depends, and the Court of Protection completely appreciate that for some individuals, unfortunately, capacity doesn't change. So, if a capacity assessment, let's say for argument's sake, for example, as for property and finances is completed in 2024, and in 10 years' time, you might need to go back to the Court of Protection for further authority or something else relating to the individual's property and finances. You can explain to the Court of Protection within that application that capacity hasn't changed, the circumstances are the same. Within the capacity assessment form that's submitted to the Court of Protection, the current form does ask the assessor whether it's likely the individual will regain capacity in the future, and that gives the assessor obviously the opportunity to detail why capacity on that point might not change, and then that can be used in future applications to say, look, we had this done 10 years ago, but at that point they said unlikely to change and the situation hasn't changed. There's no guarantee with the Court of Protection. They might turn around and say we want an updated one, but there is that option might be available if that box has been ticked.
Okay. Again, following up on that, this person's put, it's clearly a very costly process and people with children with such needs are already stretched. Is there any campaign for more fairness in this area, as it looks like we're pretty much forced into a corner where we have no choice here? Again, I think it's a lot of people's concerns around the funding, the ongoing particularly costs for something like this.
Yeah, and the ongoing cost, I appreciate it's a really difficult process, a lengthy process as well. It takes a while, and there are those sort of ongoing, as I mentioned, the Office of the Public Guardian fees are an ongoing cost. There are the options, obviously, with the Office of the Public Guardian fees as well. There are exemptions and sort of reductions available depending on financial circumstances. So if it is something that is needed, if a deputy is needed, have a look sort of at those exemptions and whether you would fit within that criteria. I'm not sure of any kind of ongoing campaigns to reduce the costs or for more fairness, but I completely appreciate what you're saying. The court, they do recognise that obviously the application fees, the ongoing fees can be restrictive for many individuals, and there are those options depending on your financial circumstances that you can look at.
Okie dokie. Helen, I don't know if you wanted to sort of chip in with some of the questions. You might not want to. I'm quite happy to do a little bit.
No, that's fine. I've been listening away. So let me see where we are up to. We've got a question about an advanced care plan. So somebody's mentioned we have an advanced care plan as well as an LPA. Do we need to give our LPA? Do we need to attach? I think they're saying, do we need to attach the two? I might need to ask that person that question again. Does that make sense to you, Kerry?
I'm not quite sure what that means.
Okay, I'll ask them to ask it again because I think there might be a typo in it. Don't worry. So the next question was around two questions around funding. So the first one, what types of funding are available to help finance the process? And the second part was, does the money for ongoing costs come from the young person's finances or from the parents' finances?
Yeah, so obviously funding the process, as I say, if we're looking at sort of the financial deputyship side, it's looking at whether the exemptions or the remissions might be available. And I mean, if it's often the case, if the individual's income is low or no income and it's just benefit income, it's a means tested process. You know, you might find that that exemption or reduction does apply. As I say, in terms of actually making that application, it's not necessary. You don't have to instruct a solicitor. Obviously, instructing a solicitor to prepare the application comes with its own costs. So the forms and the guidance is there, all available for you to be able to make the applications yourselves if that's needed. As I say, it's not always, a deputyship isn't always needed. It's very much dependent on, for a financial deputyship, what there is to manage. If it is just a case of benefit income, there is the appointeeship system through the Department for Work and Pensions already. And then does the money for ongoing costs come from the young person's finances or parents? So it is really set to come from the young person's finances. Yeah, so I appreciate that might not always be affordable, hence why the fee remissions and fee reductions are based on the young person's finances as well.
That clarifies that for me, actually, because that was the question I was going to ask. Is it the actual deputy that is paying for this, or is it the P person that pays for it? Okay.
So obviously the one of the points on that is the court application fee is kind of an upfront cost. So whilst the sort of fee exemption, fee reduction is based on the young person's finances, it might be that parents, guardian, main caregiver, they might have to kind of upfront a reduced fee, upfront that cost, but once they're appointed as sort of a financial deputy, they can then be reimbursed for that.
Okay. I'm just going. We've only got a little bit of time left. I'll try to cover a couple of more of these questions if I can. So, if there's something that's sort of slightly different so Aisha's sort of reworded a question. She's put, as the LPA health can be used if individual doesn't have capacity, we feel we need to create an advanced care plan to cover this situation related to capacity. Would you assist with reviewing an advanced care plan?
It's not something my team would deal with. I can ask the question to sort of the team dealing with lasting powers of attorney for health and welfare, if that can be followed up.
Okay. I've got a question here that says, is the first stage of a COP1 form, regardless of route, followed, i.e. LPA or deputyship?
No, so apologies. So the sort of the COP forms, they are applicable to deputyship, so where a person lacks capacity. Lasting power of attorney documents are separate and are separate documents to that.
Okay, great. I think that actually does cover pretty much. I believe that covers all the questions in the chat.
Yeah, I think it does.
Just checking Q&A again. I think that's fine. One of the questions was around to save someone note taking. Will the presentation be made available? But as we're recording this anyway, that people will get that. We'll make sure that people have a copy of the presentation. And there was one on my mind that I was thinking about, and it's completely gone out of my mind now, so I can't remember, but we will follow up.
Well, if you think of anything, yeah, you have my details as well, so you can get in touch.
Oh, okay. I've got a point. Oh, I didn't see that. Oh, they've come. I see. They've come up before those ones. So sorry, if you don't mind, we'll run through a couple of more questions quickly. As a parent, who is it that should provide a capacity assessment for these proceedings?
So for a deputyship, there is a COP3 form which sets out sort of suitable professionals who can carry these types of assessments out for capacity. So it could be medical professional, sometimes it can be a GP, depending on the decision in question and whether the GP feels comfortable doing a capacity assessment. You will find that some GPs might think that, you know, someone with a bit more specialism might be required for a capacity assessment. So it can be a medical professional, social workers can complete the assessments. So yeah, there are quite a few options.
Okay, because one of the questions is a person's GP said they needed a deputyship to be able to arrange repeat prescriptions. Is that correct? That sounds rather extreme to me, but Kerry, I'm sure you can advise whether they need a deputyship for repeat prescription. I mean, I've fallen into this before now with GPs, where they've, when Lily, my daughter, turned 14, I was told that she has to manage all her medications going forward. Clearly, that's not, you know, going to happen. But we've personally not needed to have a deputyship in place. But is there any legal?
Because health, as I say, health and welfare deputyships are quite rare. So the Court of Protection would, you know, prefer, as I say, for that kind of collaborative best interest approach to be taken in terms of health decisions. I can speak obviously to someone in our public law department who deal with health and welfare deputyships, because I've not come across that a health and welfare deputy is needed for solely you know, repeat prescriptions. Obviously I don't know the full circumstances, but if it's something that is becoming an issue, I'm sure someone from our public law team could have a look at that.
Okay, great. Great. I think is that Helen, Jackie, anything else that we need to cover before we finish here?
No, I think just to say a couple of people have asked questions about the copy of the presentation, so we will send it to you within the next week, and everybody who's registered as an attendee for the webinar will automatically get a copy. But if there is anybody who you think may benefit from the presentation who isn't registered, then at the start of the presentation, mine and Leanne's email addresses are on there, so just pop us an email and we can send the presentation out to anyone that we may have missed.
And hopefully everyone will be seeing a poll. My poll, it's 3 questions, as I said before. I'd be really, really grateful if everybody could take literally 2 to 3 seconds just to answer those questions so that we understand and know whether this has been a useful, helpful to you to learn more. It'd be great. I want to say an enormous thank you to Kerry. That was really great. If anyone does have any further questions, as I said before, please do either direct them into us if that's the easiest option, or this will become available so that people can then get in touch directly with Irwin Mitchell and Kerry and her team if necessary, whatever works best for you guys. But I just want to thank everybody for coming. I really appreciate it. It's been really good. I've learned something new, so I'm really pleased about that. And thank you again, Kerry, for presenting
thank you
tonight.
very much, everyone, for taking the time out on a Tuesday evening. So thank you very much.
Thankfully, my electricity didn't go down.